Hi, everyone. Please welcome Panel 3 discussing trauma-informed advocacy for survivors of domestic violence, sexual assault, and trafficking. This panel will cover sensitive topics, so please feel free to step out at any point if the discussion becomes too difficult for you to listen to. I will now turn it over to our moderator, Emily Sack, Professor of Law at Roger Williams University School of Law.
Thank you, Elijah. So welcome everybody, and again, I want to echo really great thanks to the Law Review for putting on this really important symposium. So I'm going to first just introduce each of the panelists, and we're really lucky to have so many prominent people here with us today. And then I'm going to ask them some questions, and there'll be some time at the end for anyone who would like to ask further questions from the audience. So first to my farthest right is Dr. Amy Goldberg, who is a professor of pediatrics at the Warren Alpert Medical School of Brown University and also an attending physician at the Child Protection Center at Hasbro Children's Hospital. She received her medical degree from Boston University School of Medicine, and she has a fellowship in child abuse pediatrics at Hasbro. Her clinical and research interests include domestic minor sex trafficking, injury patterns in children with developmental delays and differences, and establishing normative data for patterns of physical injury. To my immediate right is Erica Hardy. Dr. Hardy is an associate professor of medicine and obstetrics and gynecology in the Division of Obstetric Medicine and Infectious Disease at the Warren Alpert Medical School at Brown. She is a specialist in infectious disease, particularly in the peripartum period, sexually transmitted infections, and trauma-informed acute medical care and follow-up of sexual assault survivors. Next to Amy over there is Taylor Matook, who is a Special Assistant Attorney General in the Rhode Island Office of the Attorney General. She specializes in the Special Victims Unit and oversees a case of over 250 criminal cases, primarily composed of domestic violence, sexual assault, child molestation, and human trafficking. Talk about trauma. You're telling a lot of it. She also serves as a member of the Rhode Island Human Trafficking Task Force, and while she was a law student, she served as co-founder of the Human Trafficking Prevention Project that was Connecticut's first of its kind, or originated out of Connecticut's first of its kind legislation requiring all hospitality industry workers to receive training on how to recognize and report signs of human trafficking. And finally, to my right is Vanessa Volz. Vanessa has been president and CEO of the Sojourner House since 2011. During her tenure, the agency has updated its mission statement, more than quadrupled its budget, and developed new community-based initiatives and housing programs. She's an attorney and previously practiced disability rights law, and she is currently, in addition to being the CEO of Sojourner, she also teaches at Rhode Island College in their Gender and Women's Studies program, and she has served as a visiting professor at Wheaton College. She is a graduate of Georgia School of Law, Bard College, and Leadership, Rhode Island. So thank you all for being here. Let's all applaud. So I'm going to start with Amy, if that's okay, Dr. Goldberg. You work directly with children who have experienced physical abuse, sexual abuse, and neglect, and you collaborate with law enforcement to ensure that they receive appropriate advocacy. When you serve as a witness, an expert witness in these kinds of cases, can you explain your role as a witness and the crossover between the sort of medical and legal interests in working with these clients?
Sure. First, thanks for having me. And I'm really honored to be on this panel with you guys. So my role really is I'm a doctor. I take care of kids medical health, their physical health, their emotional health. And that takes precedence over everything else, even if it compromises the case. So if Taylor wants me to examine a kid or interview a kid and it's not in their best interest and they're not ready, I say to Taylor, they're not ready. So while you ask me a question about my role as an expert witness, my job is to be this child's pediatrician that day and potentially for a few days, other visits in the future. Because of what I do, because I obtain a history, which means just finding out from this child what happened if they can tell me. If they're an infant, they can't tell me. But if they can, that's obtaining a history. I then do a physical exam. I then interpret x-rays and order lab tests. And within all of that, there might be evidence that now I have. And I'm really aware of that. So physicians have, as I'm speaking to, like at Roger Williams University Law School, an exception to the hearsay rule. And I recognize that. So because of that, I will never take that history with an attorney present. How did that happen? With an attorney present, or with a police officer present, or even with DCYF present, because that child is coming to me so that I can help that child get better for help. And therefore, I have that exception to the hearsay rule and can then testify for them in court. So my role is, it's not forefront. It's not what happens. It's not what I consider my job to be. But because I am in this position as a physician and I really recognize that privilege that I have in taking care of these kids and then potentially can advocate for them in court, I'm really cognizant of what I do day to day so that I don't breach that responsibility that I then have later.
Great, thank you. Dr. Hardy, how do you explain the key components of trauma-informed acute medical care for sexual assault survivors, and how do you think we in the legal profession might learn from you, from the medical profession?
Yeah, I mean, I think again, thank you for having me, and it's great to be on this panel. There's so many overlaps between medicine and I was thinking law school and medical school, and as you can imagine, the medical system itself is not very trauma informed always, and I think we're all looking for ways to make that better. And so, I think some of the things that I try to do, because again, I'm a physician, and so I think about my role as a physician to the patient that's in front of me. And I think some of the things where there is carryover are things like giving a patient choice, asking them simple questions that they might have choice over that kind of gives them back agency. Trust, we have the privilege of being present in a time in our patients' lives when, whether it's they have something else entirely, Staph aureus bacteremia, or, not just sexual assault. When they're vulnerable, they're looking to us for advice, and our responsibility is to them. So I think that trust is important, and so I think things as simple as saying what you're doing and why you're asking questions and doing what you say, following up on what you tell them, things like that can all be, and then the follow-through piece too, following through with what you say. And those are some of the, sort of very simple things in a patient-provider interaction. And I think there's a lot of carryover to many professions, including lawyering.
Mm-hmm. Thank you. Taylor, so as I said before, you work with, lots of different types of survivors of trauma, and I wondered how you deal with that work and how you ensure that survivors are in fact being treated as survivors as opposed to offenders, as we were talking about before. Sometimes victims of trauma come into the system potentially as defendants, or like in sex trafficking or domestic violence, et cetera. And so I just wanted to get a sense of how you deal both with clients who are complainants in cases, but also who are defendants in cases?
Yeah, thank you.
Yeah.
This is a really important question because you do interact with all walks of life in this profession, and you have to go in without any preconceived notions, but also with an understanding that they might have a background that is different from yours or different from what you expect. In a perfect world, you'd get a perfect victim in a case where the case was perfect and a defendant would plea and you wouldn't have to worry about anything else, but that's not the case. We get victims all the time with their own records, and that is, of course, something that we have to address when it comes time for trial. But it is also something that from the onset of the case, you have to work really hard to establish trust. My office has been trying to get prosecutors that will be assigned a case later on involved in that investigation and that process as early as possible. So that way you're not an unfamiliar face. You're not the 10th or 20th person that this, survivor has spoken to about their experience. And that on your end, it's also not just another file that's been placed on your desk, one of 250 or whatever it may be. So by getting involved in the onset, you are able to really learn who your survivor is and what their needs are. And also that they might not want to trust me. As a prosecutor, I am technically part of law enforcement, and they might have had really negative experiences with law enforcement in the past. And that is something that I have to be extremely aware of because now I'm coming in with a lot of control, or potentially their only representative going into the courthouse, speaking with the judge, speaking with the defense attorney. And if they don't trust me, that's going to cause a lot of hurdles for me to try and get them the best justice that they deserve and that I can try to get out of the system. So by establishing the trust, if you can, it's meeting with them, it's explaining to them, I am on your side. I'm listening to you, I'm hearing you, I'm acknowledging what you have gone through, and I'm here to help fight for you and hopefully have your voice be heard in court. That's a lot easier said than done, and it takes a lot of time. It takes a lot of meetings, but it's certainly not impossible. It's just making sure you're aware of what your shortcomings are in their eyes and vice versa, and explaining that to them.
And Vanessa, this is another classic issue with trauma-informed lawyering and advocacy. When you have survivors of interpersonal violence or sexual assault, there's often a tension between wanting to give them as much agency as possible, and also how to advocate for them, which doesn't have to be mutually exclusive, but sometimes can be a tension. And I just wondered how you and your agency and your expertise, how you work with survivors who are in that situation.
Absolutely. And I also want to thank the organizers for this event, and so nice to see many colleagues here. There are a few of my coworkers from Sojourner House in the room too. I hope you get to meet them.
Former alum of Roger.
Yes, we're very excited to have her. In terms of advocacy, the most important aspect to keep in mind working with survivors of trauma is that no one knows their life the way they do. And they have to be the one who is making the determination about what direction they want to take, whether it's what kind of services and supports that they want from an agency like Sojourner House, or whether it's charges against their abuser or seek custody. They're the ones who have to live with those decisions, and so they're the ones who have to make those decisions and drive the strategy. I think where the legal advocacy comes into place is, as lawyers, we have the tools, we have the connections, we have the networks, we have the ability to put things into motion. So we should really follow the lead of what our client or the survivor we're working with wants, what their ultimate goal is. And that's an important perspective too, is just, I think oftentimes, especially at Sojourner House, we're so consumed by the emergency situation. So many clients come to us because something immediately has happened, they've just experienced a bout of abuse, and we tend to immediately address that situation, which we need to, but we also need to think long term. And this has really driven a lot of the programs that we've developed at Sojourner House, for example, we don't just provide emergency shelter. We've built out a very comprehensive permanent supportive housing program because we know that survivors need long-term housing. And so it's really important to think about, what does a survivor ultimately want to achieve? Yes, we want to get through this immediate crisis. We want everyone to be safe, but what are they ultimately seeking? Do they want the relationship to work? And I think that's sometimes something we don't talk about as much in the domestic, but we do sometimes have victims and clients who want to try to make the relationship work. And again, that is their choice. And our role is to provide them with information about how that can happen safely. Or maybe they do want to move to another situation and they don't have money to pay rent. So how can we help them do that? Or maybe they do want to take legal action through family law recourse or have other legal matters that need to be addressed. But yes, we have lots of information as attorneys, but ultimately we have to take the direction from the client. And I also think it's important especially if you're talking within the sphere of victims who've experienced domestic or sexual violence, the abuse that they have experienced includes this element of power and control. And we have to be very aware that in the legal field, we as attorneys or we as the legal system wield a lot of power and control. And that can be very intimidating and that can mimic abuse in many ways. So we need to be very mindful of providing options. Here are different ways we can address this situation. Which option feels best for you and your family? I don't know the answer to that. I can just tell you what your options are.
Great, thank you. And sort of building off that, this is a question for any and all of you, which is that obviously many survivors of domestic violence and sexual assault have several different, maybe historical traumas that are not necessarily directly related to the particular case. And also, of course, as Vanessa was saying, bring different identities and experiences, race, gender, class, etc. So what is your approach to address a client holistically? I mean, Vanessa was just saying to kind of meet them where they are. But how do you really work to do that? And I think, Taylor, you were saying, realize that you may not have the same experience as they do. I'm just interested from all of you, both from the medical and the legal perspective, how do you actually do that in a way that will be most effective in taking into account all this history of trauma and particular experiences?
I can start.
Mm-hmm.
My experience, in order to really view a case and approach it holistically, is to make sure that I'm informing the survivor involved in my case fully of what is going on in the court system. I never want them to feel like they're going to be blindsided or that I'm single-handedly making decisions on their behalf without discussing them. So from the bat, I am probably over-explaining and maybe even word vomiting to them everything to expect, what a judge might think, what the benchmarks are, what case law says. And I have to have the hard conversations too about what a defense attorney might be thinking, what their arguments and defenses are going to be, what hard questions that they are going to have to come across. And I try to vet through those first with my survivor before they have to ever come across a defense attorney cross-examining them first. So I think being well informed, not only on our end, but on their end as well, really helps, because now they feel like they are a part of the process, which they absolutely should be, and their input is huge. Similar to what Vanessa was saying about sometimes these victims and survivors, they want to stay in the relationship. And a lot of times I'm probably getting yelled at on the phone by my survivors more than I'm getting thank you, because they're saying, well, this case is dividing our family. We just had a baby, or we have 3 kids together. How am I going to afford rent? He is the sole provider. Now we have a no contact order that I didn't want in place, and I can't even figure out how to do custody exchange. And these are very real, very practical problems that survivors have to overcome. And I have to be receptive to them. And of course, I might have different ideas of how a case can go. I might have an outside perspective of, well, you have been in danger. This person has been, violating you. But they still want to be with them. So how can I take that input into my decision making? Well, I'll say, okay, there's a no contact order in place, and I don't think you should have any type of physical contact. But it sounds like childcare is really hard for you and you're really struggling. So why don't we go to the judge and we can see if he will amend it to allow for communication for childcare purposes only. So you have to be willing to stand your ground in what you think is right and follow the law, but also to make sure you're meeting your survivors where they are as well.
Amy, did you want to say?
Yeah, I was just thinking about kind of our different, we attend a meeting together every week, and I learned from my colleague Meg Fitzgerald that she says this a lot. What the justice system, what justice means for the legal system might be different from the justice for the child. And so to just recognize that I had a really interesting conversation before the break about mandated reporting and what we all have to do, and sort of all of these things that we all have to do. And then I have this child sitting in front of me who's had this incredibly traumatic thing happen to them in the context of a relationship. So I always say I get to be a doctor. I get to do this like really basic thing, which is help someone who has come to me for help to take care of them. So I feel like in this room, like all the medical providers and people who work in that setting have like sort of this easy job because we're just listening and actually finding out what is really relevant and important to this child, understanding child development and all of these important relationships, and then sort of passing that along. Trauma-informed lawyering or care that we do together is me sharing that with you, me sharing that with the police officer who's then going to talk to this child and is in uniform and has a firearm and all of those things that can be really scary. The other thing is, you didn't ask this, but I just also I go to the so-called cocktail party, which I actually never go to, and people say like, how do you do that job? You're a child abuse pediatrician? That's so depressing. That's so traumatic. And I just think there's so much healing in this process that can happen if it's done correctly, if it's done with this trauma-informed care that we just keep all referencing over and over again, slowing down and sharing information, the small things that Meg is like really, really good at. Gosh, I loved that. Like wearing the color that the child asked you to wear. Actually remembering their name, remembering their mother's name, using people's, not calling them mom, calling them by their first name is really important. So all of these little, really small bits, I think, are kind of universal. And for me, in light of the vicarious trauma thing, which is a big thing for me as well, is the thing that I walk away is sort of recognizing what we can do as professionals working together to actually make something right that has been very, very wrong.
Thank you.
Yeah, I think with that speaks to me too. I think a lot of times with the medical profession, folks have not had a positive experience leading up to this many times. Sometimes they have, but sometimes not. And, thinking about what you can actually turn that around, and you can do little things that may turn that experience around for them. You can do some things that are sort of harm reduction. Well, if you don't want to do this, or we can do this. We have pre-exposure prophylaxis for HIV and STIs, and we have all these tools that might not be necessarily like what you'd want for them, but might be the best solution for them and what they want. And taking care of an adolescent who then you get them into adolescent care, and they might get on birth control that they wanted to do, and get into primary care and have a medical home now. So those are the positive things that can come out of this.
Something that's coming to mind hearing my colleagues speak about trauma-informed approaches to doing this work is that oftentimes clients who have experienced abuse are not going to tell you everything after the first meeting. And being back in the law school is reminding me of my legal education. And I remember taking a class where it was all about how to interview your client. You sit here with your notepad and the client sits here and you ask these prescribed questions. And that's really not how it works oftentimes when you're working with a survivor of trauma. And I'm having this recollection. Before I was at Sojourner House, I practiced law at a nonprofit. I did civil rights, disability discrimination work, and I had a client who called me. She had been committed to a psychiatric hospital. She wanted out of the hospital, so I went to the hospital. I met with her. I did the prescribed, let me ask you your questions. And something felt off. I just felt like she was not telling me the whole story, but I was able to get her out of the hospital. She really didn't need to be there. And she called me afterwards to thank me, but when people talk to you and you just have a sense they are saying a little more. So I made an excuse to go visit her at home, which I'm not saying you should always visit your clients at home, but in the work that I did, it was not unusual. And I visited her at home, and I did not have my notebook of prescribed questions, and I was just asking her about different things and having her show me her home. And she opens up a door and she said, and this is the basement. And then she looked at me and she said, that's why I wound up in the hospital in the first place. And I said, what do you mean? And she said, well, my husband pushed me down the stairs. And I looked at her medical file when I was representing her on the commitment, and there was no mention of an abusive husband at all. She'd been married for 50 years. And this then just opened up a floodgate. She had been abused, physically abused her entire marriage, and never really had talked about it to a medical professional, certainly not to an attorney. And I tell this story just to reiterate. I often say when I give presentations about domestic and sexual violence that abusers don't walk around with a sign that say, I'm an abuser. And the same could be said for victims and survivors. They don't walk around with a sign that says, I'm a victim or a survivor. And there's so much stigma in our society. A lot of people have had these experiences, don't want to disclose it, even to their attorney. And I know as attorneys, we think, oh yes, people are going to tell us everything. I'm their close confidant. I'm here to counsel them. But just know you still have to develop that relationship with them. You still have to develop that trust. And that really is taking a trauma-informed approach to doing this kind of work.
Thank you. And that actually leads me to another related question, which is that, we heard from our speaker at lunch about, how important it is to take time to yourself and to create boundaries, etc. But the problem, for me personally, who does not have good boundaries in this area at all, is that sometimes it feels like to be the best attorney or doctor with clients that have trauma, you have to kind of bond with them and develop trust with them, but that's also more directly, giving you more trauma, I guess. So I don't know if I've expressed that well, but I think you understand what I mean. So I don't know if anyone has a comment on that. And since I invoked you, I'll let the lunch speaker tell us what she thinks too. But yes, go ahead. If anyone, you want to go ahead, Amy, or yeah.
Sure. You want to go?
I'll go if
You
you want
go.
me to. Okay.
Go ahead.
Yeah, it's really hard to not take on either your clients, or if you're representing them like I am, the state's interest, survivors' trauma, especially because you're pouring in hours of work on these cases, and you've met with them how many times, you've met their families, you feel very, very connected to what they've experienced. And we've talked a lot about how the court system has a lot of shortcomings. The jury system has a lot of shortcomings. I've had several cases where I was starting to lose faith in the jury system, and I was like, who thought of this? And I can't think of anything better, but what can we do? But one of my first trials where I was the lead, first chair, I had what seemed like the perfect victim, no record, cooperative, parents were involved, great support system, took the stand beautifully. It had part of it was not a sexual assault, just a regular assault, a felony assault. Part of it was on video. It was a strong case. And the jury came back not guilty on all counts, including a disorderly, which clearly had been established. And when we spoke to the jurors after, they said, well, we just, we didn't really understand the language of what a disorderly meant. And so we just decided not guilty. And with the felony assault in the video, it was with the car. And I go, you could see the part where the car had slightly run over the body and gone off. They go, but that actually, there could have been a pothole right before it hit her, and you couldn't really tell. So we went not guilty on that too. And it just blew my mind. And I remember thinking, oh my God, I have to go back and call this family and tell them what the result is and what the jurors were thinking after I just made the poor family all take the stand and testify about something really traumatic. And honestly, the case could not have gone in better. So you can never predict what's going to happen. You can never predict what a jury might be thinking, no matter how well you've done voir dire and you've selected them. And so you should also never, just as a side note, you can never guarantee anything to your clients either. You cannot tell them this is going to be a win, it's no problem, because you don't know. I never like to make false promises. I like to tell them very realistically, here's our strength and here's our weaknesses. But this was definitely a blindside, and I got so emotional about the thought of having to tell them what happened that I remember I started crying the second I got back into my office, and one of my chiefs was like, hey, there's no crying in prosecution. But I was like, oh, there's crying for sure in prosecution, because you do take it on. And it's something that you either become jaded with later on or you fully feel at some points. And I think everything that has been said earlier about really trying to figure out what your self-care is really crucial. But we're also only human, and we're going to feel human emotions. And I think you need to sometimes allow yourself to feel that way. And then you pull yourself back up and have those hard conversations. So it's not easy, and I'm sure I'll probably cry again, but I don't cry in court.
Anyone else like to respond to that? Or? No, Amy, did you want to?
You choose when you're going to share
Yeah.
parts of who you are in situations.
Yeah.
You don't do it all the time. Don't do it all the time. It's not professional, actually. And until you're actually experienced at doing it, I would say don't do it. So because this isn't about you. This is about them. You don't use the word "I understand," and even if you do, you don't use that word. I understand what you're going through. But back to like sort of how close do you get?
Yeah.
They don't need to know how close you are, right? Like, I think it's, that's why you have colleagues. I wanted to add to, you did put this slide as like the trauma-informed approach for yourself is to have a trauma-informed team. So that my colleagues know that when there's a removal of children who are going to be placed into custody, which very rarely happens now, siblings are placed in separate homes, but when they were, I wasn't good. Like, that was not good for me. Bad, very bad. Like Meg Fitzgerald would know, oh boy, like there's gonna need to be some crying after this one. Of course, I'm not going to do that with those children in that moment. And with teenagers or when I have a fellow who's trying to connect with a teenager by acting like a teenager, I pull them aside and say, please don't reflect your patient. You're no longer a teenager. Act like their doctor. They've come to you for help. They've come to the attorney for help. And so you need to present yourself as I can help you. That doesn't mean that you're not having your own personal and internal experience, which is processed separately. Every once in a while, you do say, and I say it more now because I feel like I have a little bit more control over it. I do say to a mom sitting across the table, yeah, it's really, really hard to be a mom, as a mom, right? So, but I didn't say that even when I was a mom to young kids before. I'm just saying you really choose your moments, and you do it pretty. I think you do it pretty rarely, not just because of like vicarious trauma, but because of
Well, I was going to mention that too. I think it's entirely possible to be empathetic with your client, to establish trust, and to still have boundaries. And I'm remembering a client I had, again, when I was an attorney, who was working on, it was a long-term case, so we knew each other for several years. And there was a period of time where she called me, I'm not kidding you, every day. And it was a 5-minute conversation. And it was more than just, how's my case going? Like, she just kind of needed the emotional support. And it really was never more than a 5-minute conversation. So it was fine. I always took the call. But I do remember early on, she called and she said to me, it was a Friday afternoon, she called for a check-in, and she said, can I call you tomorrow? And I said, tomorrow's Saturday. I said, I don't work on Saturday. And she said, well, can I call your cell phone? And I said, no. You can't call my cell phone. I don't work on Saturday. I said, you can call me Monday through Friday. And she was okay with that. But you have to set those guidelines. And if you don't, you're not going to have them. So I think it's fair to say set whatever your guidelines are. And for some people, maybe having her call you every day would not be okay for you. But we all have to figure out what works for us, but be firm in what your guidelines are.
Eric, did you want to say anything?
No, I mean, I think that, what both of you said is so true that, you can, I think, sometimes you'll see little breaches and that, I remember when COVID first started, patients would be like, do you have enough masks? And I'll be like, we're doing fine. And in my head, I'm like, it's horrible. We're not doing okay. But, you sort of maintain that professional, but you see glimpses of like your patients do see you as a person, but also, as a professional, and maintain that. And I really liked your slide about finding your why, because I think that is so helpful. And I think I think about that a lot. Like, Amy and I were talking about, we love our jobs, and, to some people, being an infectious disease doctor during COVID might sound awful, or, running follow-up clinic after sexual assault, but there's so much good in that and so much why, like you feel meaning in your day to day. And I think not everybody has that. And that's a gift. So.
Sort of switching gears back to talking about clients, I know all of you have experienced this and are experts in this, which is that a lot of times clients in these situations do not have what we would think of as typical responses. So they may minimize violence or trauma, they may act sort of cold or have low affect, they may change their stories many times, things like that. And I wondered if you just first of all could explain that to our audience, but also how you work with that. So anyone who'd like to take that first?
Sure, I can do. That's my wheelhouse is switching stories, or not being ready to talk about what happened, taking care of children. But we've been talking about mostly adults in general. I always think that when trauma happens, no matter who it happens to, it makes us feel so vulnerable and sort of childlike. So I think, all of the things that we do for children and explain the process, this is an aside, sorry. This process that we do with children of bringing them into the courtroom and explaining who sits where, do that for adults too. You?
Yeah.
Because they're so vulnerable as well. So the disclosure is a process. It is not an event. So this idea that someone would change their story, omit something, or can't, is actually expected. It is children disclose childhood trauma, sexual abuse, physical abuse when they feel safe. And because they've been sexually abused or physically abused or maltreated in any way, they don't feel safe. So the way that process happens is first by a child. I think of it as like sort of throwing out a bone and seeing what the adults are going to do with it. Are they going to like throw it back at them? Are they going to be like, this is not or are they going to say, tell me more. I'm here. I'm going to protect you. I'm not going to leave you. Yeah, I can't pay the rent. Acknowledging sort of this thing. Someone else, I think Meg brought that up, is this fear that this child might have. But I believe you. I support you, and we're going to get through this together. That is like the response that will allow that child to feel safe potentially. The other thing is that we don't know what that child is feeling unsafe about. So it might be all those things that I said, but it actually might be that they kind of liked it, that they kind of enjoyed this relationship that they had with this person, usually someone who they know very well, and feel a lot of shame about that. So all of the reasons why children, because that's who I take care of, don't tell you everything all at once is for so many different reasons. And I think the expectation needs to be that this is a process. And when that child is acknowledged and feels safe in that process, then they will be able to tell us, which can lead to a healing process, not just for that child, but also for the whole family. The other thing in terms of how do we support that is by not necessarily asking the question, why didn't you? When you hear yourself saying, why didn't you tell right away? Why didn't you push him off? Why didn't you say no? So why didn't you questions? It's like sort of there should be a little bit like, wait, is there another way of doing this? And another way, one of the many other ways is to think like, you're telling me now, what made you want to tell me or be able to tell me about what's going on? So recognizing that a lot of trauma, maybe not all trauma, but the trauma that I deal with in my work occurs within the context of a relationship. Like everything is relationships driven, really. And so that relationship might be defined by society as being horrible, but for that child, it might be the relationship that they have with their father, their ex, X, Y, Z. So there has to be some acknowledgement of that, as well as the acknowledgement of that whole process.
Thanks.
Well, in terms of adults, I think it's important to look at the culture that we live in. There's still so much victim blaming that a lot of adult clients that we work with, they have that fear that they should have done something differently, that somehow it's their fault that they were abused, or they should have left sooner, or they're a bad parent because there was abuse going on in the household. And it's really important to be aware of those external cultural influences that really do still permeate today, that can really influence someone not disclosing all the details or the extent of the abuse.
Vanessa had touched on this earlier too, about how disclosures, and you had just said it as well, it's an ongoing process with building trust. And just to put it into perspective, when we first get some type of report, whether it's been through DCIF or if a school has reported it in or a parent has reported it, I mean, these kids and adults are first meeting with police. Then they're either going to the Aubin Center for that, medical examination, or they're going to a forensic interview first, one of the two. And then they've had multiple conversations already with multiple different people about what's had happened, multiple different recorded statements. And then once it comes to me, we might have to have a bail hearing, or if it's a capital offense, it might have to go through grand jury. So now we have several different statements. And with trauma and the memory and how we perceive things, it could show up differently in every single statement. And that doesn't mean that they're lying. It's just how their memory is processing it. And with so many different audiences before them, you have to expect that there are going to be differences. And I think that's something that people who have a trauma background, or what we're speaking with today, people in this room would understand that. But defense attorneys love prior and consistent statements. That is their fuel. That's them being like, got it. No way this is going to trial. Don't you see this? Hey, she said 5 different things. So you have to find what is linear and what won't be linear. And you cannot expect it all to come out at the same time. I mean, I was prepping for a trial with a survivor, and we had met multiple times to get her ready to testify. And at the 3rd meeting, she said, well, you know what, I really want to tell you that this wasn't the only time this happened. And she brought out a whole brand new incident that had not come out in any statements before. And it took her that long to get to that point with me and my advocate in order to come forward with that. And of course, you get defense attorneys because you have to supplement discovery with that disclosure. And they'll say, well, if it really happened, she would have talked about this a lot sooner. She must be making it up, because how could she have talked to 5, 6, 7 people and all of a sudden now there's this whole separate incident? It's made up. So you really have to be ready for what comes with either delayed disclosures or the lack thereof. But honestly, delayed disclosure are pretty much most of my cases. I have a few that are immediate. It's something that we have to be prepared for and expect, and it is normalized. But again, that's ammunition that might be used against you, but it's totally expected. It takes time for people to come forward. And funnily enough, I just had a meeting yesterday with 2 defense attorneys. We were going over a phone dump of a juvenile victim who had a relationship with an older neighbor. And in the phone dump, she had some group chats with classmates, and they were talking about, it was in a women empowerment class. And the defense attorney says, well, she took a women empowerment class. They had to have talked about sexual assault and how to report it. So she knew how to come forward, and why'd she wait 2 years? And I was like, okay, so it's going to be one of those conversations. So just be prepared for that.
Erica?
No, I think just building on what Vanessa had said earlier, sometimes being okay with not, with the disclosure being in medicine, we want to have like a successful interaction or get all the information if we're doing it right, in terms of the interviewing. But maybe just think about it as sort of setting the stage for later. You might have demonstrated that maybe your person, Vanessa did that. She felt that could be disclosed to at a later date, so. Being okay with sometimes not, it doesn't mean anything's wrong. It's their expert knowledge. They have their own knowledge of themselves, and they're the only ones that do.
So that's both of you a really good point as well, because sometimes I'll go into meetings, and as lawyers, we have our checklist of information, questions, and things that we need to get out, and you have to hit all your elements and things like that. And a survivor's mindset is not going to be the same. You do need to practice patience with yourself and also with your survivor too. Sometimes that first initial meeting, do not stress yourself about getting everything. You need to build the rapport. And a lot of times, if they're willing to talk, they just want someone to listen. So instead of interrupting and saying, what was that name again? How do you spell that? Where was that? What was the timeline? Just let them flow naturally. And like you said, expect things to come out later and be patient with it.
Great, thank you. So I think we have a few minutes left to open it up if anyone in the audience has questions. So if you do, if you could either talk very loudly or come up to one of the slides. Okay. Go ahead, Will.
So as we know, storytelling is so important in many different areas of law, but particularly for people who have experienced domestic violence or sexual assault. So what are some trauma-informed tactics that you can share with the group around gathering stories from clients and educating and preparing clients to share their story in front of a jurist?
Yeah, probably someone looking around like, that might be me. Storytelling is a huge part. I will say statistically, a lot of cases do play out, and victims and survivors, they might not get the chance to tell their story in court, because at the end of the day, it is a defendant's right if he wants to trial. It's not the survivors. And that's also something I have to explain a lot is, well, I understand you want to try. They might want a trial, which is rare, but they might want it. And you have to explain it isn't your decision. But in order to prepare them, there's a lot of meetings. And you never want to coach them. You're not supposed to coach them what to say. You're not putting words in their mouth. The biggest tip I always tell them, and I end every meeting this way, is when you go up there, I want you to tell your truth because only you know it. And a lot of times, cases of sexual assault, child molestation, no one else is in that room except the survivor and the defendant. So it's a lot of times it's a he said, she said, and I warn them of that. The jury is going to look at you and they're either going to believe your side or they're going to believe the defense's argument. And the only thing that you can do and the only thing I'm ever going to ask you to do is to tell your truth when you're up there. So there's a lot of prep involved. I had a case recently where I had really great 404B evidence. It was other character evidence, and I had a motion. It was allowed to come in, and I had prepped the victim. And I always prep them. These are the things that you can speak of, and here are the things that you can't, because there's some things that they can't get into. And we went over everything, and I had reminded them, I had that motion. You are allowed to speak on this topic, and that can come in. And then, again, testifying is really scary. And as much as you prep them and tell them what to expect, sometimes you hit that stand and you go up there and it's like a deer in headlights because it is very intimidating. And when I got to the questions as to this, I was so excited to get this in the 404B evidence. It wasn't I forgot. It wasn't that thing didn't happen. It was like, no, nothing else. And I was trying to prompt this witness with every kind of word I could to try and get it out. And eventually the judge is like, move on, counselor. And I was like, but when I spoke to her after, she just was like, she completely forgot. It's overwhelming. We have to remember too, there was a conference I was at as a law student where a presenter had said, you have to picture that these survivors are going up on a stand in front of a judge. Typically it's an old white man that they've never met before, in front of strangers that they've never met before, in front of the person who perpetrated the offense against them, and they have to, in painstaking detail, explain what happened. And this presenter had said, I want you all in the audience to picture a consensual sexual experience that you had, an enjoyable one, and imagine having to share that in a room full of strangers in detail. And that, to me, it was mind-blowing. I was like, that is such a good perspective, because nobody wants to talk about that, no matter how great it was or consensual, versus now, okay, well, here's a situation that was extremely traumatizing that you have lived through. Please, to the class, explain what happened. So that put a lot into perspective in how I try to prep survivors. But it is a lot of prep, and it's also, no matter how much you do, it might not be enough.
I don't know, those of you doctors want to talk at all about either working with children in that area or sexual assault survivors?
We, getting a history from a child is getting their story. So prompting a narrative where you're asking non-leading questions that are, open-ended questions so that children can tell their story. There's lots of models to prepare, again, children to be able to do that through children's advocacy centers, through like forensic interviews. If you have a case that involves, a child who's gone and talked with a doctor, that's potentially a good place to start. That if you have access to the medical record, it could be a way to understand with your client what they told the doctor, because oftentimes something that they tell their doctor or their medical provider is their story, or at least is beginning of the truth of their story, because what they're going for is potentially different than why they went to make a report to law enforcement. Mm-hmm. So that can be a way to start that process.
Any other questions? Owen, hello. Nice to see you.
I have a question, Dr. Goldberg, or either Dr. About your experience with the hearsay exception. What is the implementation of that?
So when a patient comes to the hospital and talks about a trauma that has occurred or potentially a crime that has occurred, they're coming to me not because there's going to be an arrest made. They don't say, oh, Dr. Goldberg's going to go arrest someone, even potentially know that Dr. Goldberg's going to go make a report to law enforcement. They're coming to me because so because of that, I have an exception. It is, does anybody know that it's like 504?
I can't remember which one.
What? 403B or something? Yeah,
I can't remember.
There's actually a federal statute, and then I think there's local statute to support the exception to the hearsay rule. There was, case, I think the original case was Crawford.
Yeah, it's a confrontation clause.
Yeah.
Actually, and it's non-testimonial.
Yeah, so that I can, so especially in cases of sexual assault where there most often isn't physical evidence, the evidence is what the child said. And so how can you get to that truth of what actually happened and what that child was reporting is, I think it's argued that when someone goes to see a medical provider, that the purpose is for medical diagnosis and treatment. So that therefore I can testify to that, which is why I'm so aware of when a child is telling that to me or my medical staff or, Meg Fitzgerald, is that interview, that medical interview is for the purposes of medical diagnosis and treatment. And I'm extremely strict about not having that be messed with. So there's no one in that room who has a badge on.
I'm sorry, because I know we have like a minute left, so let me just let someone else ask a question. Thank you.
Thank you so much. Okay, it's working. First, I want to thank every panelist for being here. I appreciate your time. My name is Nana Amanko. I work at the City of Central Falls, specifically the Law Department. So my question to Taylor specifically, and if it applies to anyone else, please feel free to chime in. How do you reconcile, perhaps the way to put it, how do you reconcile the need to hit your numbers at work, from a prosecution perspective, get that conviction, whatever that looks like, with perhaps the victim's need to do things differently? I can give you an example to just put this. a victim of domestic violence. At some point in the pretrial process, I reached out to her. She said, you know what, I don't want to testify a trial. I want to drop this. I don't want the no contact order anymore. Let's vacate it. Because the defendant is using the no contact order as a reason for not coming to see the kids. For me as the victim, I want him to have time with the kids. And so, he says that I'm bringing this up so he's not getting the time to see his kids. I want to drop everything. Doesn't have an excuse anymore for not seeing the kids. I mean, in my head, I'm like, I'm not sure this is how you should let it go, but I respect what you want to do. I respect that you want the father of your kids to have that parenting time. So I'm gonna support you as best I can. Also, this person reached out to us for funding to help with her rent because I guess the defendant was the one paying the bills, and so that way. But so on that in that way, we helped as much as we could. But then there's also the issue of criminal prosecution, and she just wanted to back out. How do you kind of reconcile the two and respect the victim's wishes?
Yeah, it's not always an easy task. Every case is different. A lot of times what I'll do is, one, I first want to get that input from my victim or survivor. And I ask, what are you looking for? And I'm not asking you to tell me what you think I want to hear. It's what are you actually looking for? And 9 out of 10 times, that's exactly it. It's them saying, well, I don't want the no contact order. I'm really stressed about this. I don't want to go forward. I don't want to be in court. I'm not going to testify. But I think he might need substance abuse counseling, or he might need mental health counseling. And in those cases, I say, and a lot of times I can't prove a case without my survivor as a witness. So I'll tell them, the case isn't just going to be dismissed outright, but if you want certain things out of it, I have to pursue this to the best of my ability, and that includes you. So there's a lot of factors that go into it. One is, well, what is this defendant's record? Is this a first offense? Does he have multiple? In Rhode Island, if it's your third domestic offense and you have at least 2 other convictions, you're looking at a mandatory 1 year to serve. So in a lot of cases where maybe if it's third, or if the victim's input is, they're not denying what happened, but they also don't really want to cooperate, we do, as the AG's office, have the power to amend charges. So I could amend it to a second offense, which has 10 days as mandatory time to serve and not a year. Or a first offense, which then becomes a misdemeanor, you don't have any mandatory time. So I try to work with them, but I also don't like to amend things without reason. If I know where, a victim lives, I know I could subpoena her. Do I, tell a defense attorney, hey, I could get her on the stand if I need to, but she'd rather not. Those are the conversations we have. But I also put, some onus on the defense attorney. Hey, provide me with the mitigation package. Like, what's good about your client? And a lot of times when you ask that, you do get attorneys that really put together a mindful package. So their employment history, if it's an immigration issue, this is their family history. This is who they're providing for back home. This is their mental health struggles, or they were actually a victim as a child, and here's, the abuse that they had to sustain, and why they want to work on it. So putting all those factors together, I try to come up with a solution that will help both parties. I really don't want to force, victims and survivors on the stand if that's really what they don't want. But you're right. I have an obligation to the state of Rhode Island to make sure people are being held accountable for their actions. And so if I can come with find a resolution that will work, well, hey, she doesn't want to testify. He doesn't have a terrible record. I'm willing to amend it here, but I want to make sure mental health counseling is a condition. Or I think I had said earlier, if it's something about childcare, I'll work on it to try and get that amended for that reason. But I'm never going to agree to an outright, vacation of a no contact order, especially if it's really early on in a case. If it's closer to resolution, then yeah, let's figure it out. But there's also cases where I can't budge. I'm like, listen, this guy has 5 previous convictions on his record. I cannot amend this. His last case, he pled to 10 years full 3 to serve. That's my floor going forward. So you have to definitely hear their input, but also you have an obligation as well to make sure we're holding people accountable. And I have it opposite too, where sometimes I think a case really deserves an amendment. It could have been charged as, a sexual assault. It could have been a 3rd degree, so the ages weren't that far off. And I don't know how a jury's going to react, and I think this is something where he doesn't need to register. And I might say, I think an amendment here is proper, and the victim will say, no, I think registration is the most important. And so at that case, I'm like, okay, fine, there'll be no amendment, we will go forward, just know it might be a trial. So it kind of goes both ways, but it's definitely a balancing act. Sorry, that was so long-winded.
Thank you, and I really want to thank everyone on our panel for a great discussion.